opened by Judge Richard Mungo. Petitions, the petitioner in E-014-2024 to serve their amended petition on all parties. Similarly, the petitioner in E-013-2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October. Given that the files are being routed to Honorable Chief Justice forthwith, the parties' response to the amended petition and petition E-013 of 2024 may be filed in Kerugoya under the Kerugoya case tracking system online, whereupon they shall be forwarded now. So these proceedings took place in Kerugoya. So this court has not consolidated any matter. Petition number E-014, and petition number E-013 are hereby consolidated. The parties who appeared before the Kerugoya court were given those orders. Those were your orders.
And with your permission, presiding judge, the reason why Nairobi has not opened another file to put together all the files from Kerugoya is this. Going by the orders which were issued by Kerugoya court, there was a specific order that because of the transmission, parties will still file their documents under the Kerugoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place. Thank you.
I presume we will now raise the issues that were raised,
I have stated and I'm repeating. The reason why these matters are before us today is that after the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online to deal with matters online. And it is on the basis of only the application that and dealt with online. That is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the application which applied, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters. I can assure you there is no issue about any of the things you are raising. If you have any substantive issue, we are here. If the application for recusal, there is no problem. We will hear. If we feel we have to get out of this, there should be no problem. We are all here to defend the Constitution of Kenya. So don't you worry. Don't you worry. Give us time. Let's take this thing step by step, and we will do the best we can as a bench. Thank you. No problem.
Senior Counsel Mwite and Counsel Ndegwa, you know, when you argue the way Mr. Mugwe has argued, you are arguing on both sides because you know that we work online, and most of you know that matters reach us anytime, at any time, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead the people outside there that court sat on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had Mr. Mungai. Let it not be an exchange between the court and yourselves, because we are really very neutral party. Let us hear also from the other side.
We have been in E015. The deputy president is the second address how the process was. We haven't said our piece, and the judicial will go ahead. But Lord, do give us this ability. This E01 finding. The orders of your brother, Mr. Justice Mungo, but what community? Why did the fire come from the other to go to the Chief Justice, to go our right from the other? When did the Deputy Chief Justice sit in the middle of the night? Permit us to articulate these issues for the sake of the nation. We're not just dealing with the removal and the challenge to the removal of the deputy. We are dealing about the president that will be set for the removal of deputy presidents in future and the removal of presidents in future.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now this court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Moite. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it. Then we can respond to it. But we cannot sit here all afternoon listening to speech after speech intended for another audience other than this.
Let us be clear on this. The applications before this court, we have stated which are this court for hearing today. We have no authority to call any other file because files, when there's a prayer for empanelment of a bench, those files go direct to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite a procedural. So what we have here are the three files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, we can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific application and prayers.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, appearing for the petitioners, we were not aware of how the bench was. When it was disclosed to us that the bench was constituted by the deputy judge, it is us to address you, the Lordship, on Article 155 clause 4. On the constitutionality of the constitution of this bench to hear these three specific files. And that's the issue that we want to address even before we go to the application for recusal. Because it's our humble view, Your Lordship, that the so-called empowerment of this bench to hear this specific file is itself unconstitutional. By the reading of Article 155 clause 4, it's our reading that the only person who has the capacity to empanel a bench is the Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number two, Your Lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 55 clause 4? What was the necessity of the delegation of this function? Those are pertinent issues, Your Lordship, that requires clarification before we go to the roots of the matter, the crux of the matter. It's our submissions, Your Lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Chief Justice. That's where the confusion is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally, Your Lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That 3 files have graciously generated expediency, and other files that were consolidated, that 6 files with the lead file 522, have no reasons why it should be before you. Noting that, Your Lordship, those matters were equally satisfied as urgent and breaking heavy constitutional matters. When I looked at your orders, Your Lordship, that you issued on us today, you repeated the same, that the delays weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority, and the files with orders are the only ones that the court is sitting on a Saturday? The Chief Justice is empowering the Deputy Chief Justice is empowering the bench. We are called, in the right to speak, appear before you. Is it not because there are some orders that the state wants to forget? We cannot run away from that. We are in the Lordship.
I know the effect of it. Applications to discharge that order made by the Deputy Chief Justice. That's what we are indicating. But number 2, and it is in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that of the Saturday city and today's city, and the thing is out there in the streets of the Republic of Kenya, is that a special bench will be appointed for purposes of vacating the orders that we are making. I have a lot of respect for all of you that have appeared, but cannot persuade to my instructions that that would be the case. 3 issues worry us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoyed special privileges. Number 2, my lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my lord, and it is important that this issue is speak for the wananchi and that clear conscience. 2 things. But the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number 2, my lord, is this, the issue of bias. And this is bias by the Honorable President.
I think, Mr. Mugai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you better put it on.
Yes. Has not come to those but the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my lord, there are about 4 matters. One of them in which I appear, and this is a fundamental issue. That matter is coming on Thursday. An express order of the court has not been set. The question is, for purposes of this order, and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is the right to report it under Article 27 of the Constitution, that deals with the same subject matter come on a specific day where all parties have noticed, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say as I go to see, why I say this is important is this. The matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So that, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installment being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application is clearly not permissible.
Mr.
So that, my Lord, I
would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done. But if you have an issue with that, please don't make a generalized complaint.
Well, this is not generalized. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I sit down, the issue of that right is that we have had a situation before the National Assembly, before the Senate. It didn't seem to matter. Before the High Court, my Lord, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you, Mr.
We hear you. Yes, I mean.
With permission.
I just wanted to conclude.
Clarification, Mungai.
I am Mungai. I believe you speak in response as soon as
Proceed.
My Lord, I wanted to assist my learned friend has, I believe, filed a substantive application. The court does not hear speeches in vacuo. My learned friend should identify application so that even we taking notes know what we should be responding to. That's all I wanted to say.
Attorney General, I respect him. He was but my Lord, the point that I wish is that I am asking for specific clients today, and that's before the court. I should be having silence in this court, and I've indicated that we have formal applications. What we are raising, issue that is from what Judge Milimani has indicated, we could not put it. So if I may proceed, the issue is this.